The following content is for entertainment and educational purposes only. It does not constitute means for diagnosis, healthcare advice, nor treatment. Make use of a qualified healthcare professional for such purposes.
My name is Dr. Charlene Ortiz, and today we're going to talk about one of the topics that people are most interested in. Today, we're going to talk about that interesting intercept between psychology and law, also generally referred to as forensic psychology. As some of you may know, I hold a doctorate in clinical psychology, but my specialty is forensic psychology. And it is a field that I hold dear to my heart. I think it's an immensely interesting field. There's many areas for us to discuss today. And I also am going to link in the description down below a presentation of an acquaintance of mine that also works in the field of forensic psychology. In her specific line of work, she works in mental health, and her job is to work with the mitigation of legal aspects. So her job, basically put, she deals with aspects as to how does mental health contribute to the sentencing or the ability of an individual to receive less of a charge or less of a punishment when it comes to that individual and its relationship with mental illness, or perhaps factors that could have contributed to the crime. So I will have that presentation linked in the description below in case you are interested in looking more into, well, so what are some of the career fields that I could possibly engage in should I become interested in the field of forensic psychology. So today, we're going to talk about aspects of the definition of forensic psychology. We're also going to talk about, for instance, about matters of what is it that a forensic psychologist may do, or what an individual in the forensic field, such as my acquaintance, what are the types of work that these individuals can do, and what is the importance between psychology and mental health when it comes to aspects of the law. These could include civil law, criminal law, corrections, and other areas that we will talk about today. So let's get started. So one of the things that you will see here is I do have an illustration. I do have an illustration of some of the more relevant factors and persons who were significant contributors to the field, but I do want to capture your attention towards the bottom of the screen. Notice, as I mentioned, one of my acquaintances does work in the field of forensic psychology, and in her particular case, she holds a master's degree. Hers specifically, however, is a master's in social work. So notice that you would be able to engage in this type of work with a master's degree. However, it is generally the case that individuals who work in the areas of forensic psychology, notice that individuals who work in aspects of forensic psychology tend to hold a doctorate degree, particularly that is geared towards a Ph.D. And why is that? Well, because holding a Ph.D. gives them the opportunity to make more assessments, right? They have the ability to provide assessments to legal cases. Now, in keeping with that line of education, how is it that an individual can't prepare his or herself or anything in between? Notice that in this particular case, an individual will likely have to have a PhD. Generally, an individual who holds a PhD will be able to practice. And remember that in this specific case, you could also practice with a graduate degree. However, it is more typical that you do so with a PhD. Now, one of the things that can prepare you in regards of the field of forensic psychology is that generally, individuals who work in forensic psychology have an extensive background in cognitive psychology. And what is cognitive psychology? Notice that aspects of cognitive psychology, I should say, involve aspects of memory, involve aspects of attention, and also aspects of decision making. Notice that in keeping with that specific regard, notice that a person that is in the field of forensic psychology will be interested in, is a person able and capable of making decisions? So for example, assisting in his or her defense. So notice that it is immensely significant for an individual who is in the field of forensic psychology to also have an extensive background in the area of cognitive psychology. Now, if we revert back to our slides, notice that another interesting aspect when it comes to the field of forensic psychology is that an individual will have to become prepared and knowledgeable in the areas of social cognition. And when we are talking about social cognition, I want you to think about the aspects that are involved in group influences. And lastly, one of the areas, which is my case, is that individuals will become extensively trained and prepared or educated in the areas of clinical, which is my case, or counseling psychology. Generally, the intent that individuals may have in regards to the specific fields of clinical and counseling psychology is because they are interested in assessing for competency. Now, notice that individuals who work in the field of forensic psychology can work in a wide variety of fields. In regards to the matters of forensic psychology is divided in other subfields. So let's talk a little bit about what the fields of forensic psychology are. Notice that an individual who works in the matters of forensic psychology may become immensely interested in law enforcement. So notice that that is just one of the places that a person in forensic psychology can work under. Notice that what are the roles? What could be the roles of an individual who works in the aspects of law enforcement? Notice that a person who works in forensic psychology can engage in research, particularly in regards to this specific subfield. Notice that a researcher, an individual, can conduct research in regards to law enforcement agencies. Think about municipal, think about state and local governments, think about other areas in which an individual can work. So for instance, federal agencies of law enforcement. So for instance, FBI, CIA, in other aspects that are involved in law enforcement. So not just simply just your local aspect, but also larger aspects of law enforcement. What's another thing that an individual in forensic psychology can do when it comes to the realm of law enforcement? That is the area of assessment. The area of assessment. There are many ways in which an individual can provide services of assessment. For example, think about the actual recruit, the actual person who is interested in becoming perhaps a police cadet in order for them to become a police officer. Notice that during that process, there are many aspects of assessment. Notice that an individual who works in forensic psychology could perhaps provide that assessment to that potential recruit or to that cadet in order for them to become police officers, to see whether or not this individual has the capability and abilities that we would expect from an individual who is interested in the field of law enforcement. So notice that that could be one way in which an individual can provide assessments within the law enforcement area. Notice that assessment can also involve areas of assessment with actual police officers. So for example, think about individuals who are already in the field of law enforcement, right? So detectives, police officers, and investigators. And for those of you watching in other countries, say, for example, think about individuals who produce inquests and who are investigators in their field. So notice that a person who works in forensic psychology could provide assessment not only for the potential law enforcement officers, but also the persons who are already law enforcers. And another aspect that an individual could engage in is perhaps the assessment of individuals who are in custody. So notice that not only the potential recruit, the law enforcer, but also individuals who have been put under arrest, or individuals who are in the matter of being arrested. So people who are in custody. So notice that you can provide assessment to a wide variety of individuals within the matter of law enforcement. And lastly, one of the things that I want to talk about is another role that you may have within the area of law enforcement. That is the delivery of clinical services, the delivery of clinical services. Notice that in this specific regard, remember that an individual may also provide services as a clinician, as strictly as a clinician. And what does that mean? Perhaps providing services to persons who are law enforcers after their turn of duty. So for example, an individual, as we know, law enforcement is a very complicated field. There are many aspects of vicarious trauma that can occur. For example, persons who work in law enforcement are exposed to immensely dangerous situations, immensely unpredictable situations. And because of that, as long as many other factors, for example, becoming injured or being injured during the line of duty, having individuals who have passed because of the line of duty and them surviving, notice there are so many presenting issues that a law enforcer may have when it comes to the area of their duty. Therefore, many individuals who work in this field are indeed in need of a person who can provide, say, for example, therapy services for them, counseling services for them. So notice that that's another thing that you could do if you work in the area of forensic psychology when it comes to the law enforcement field. Notice that another aspect that an individual can engage in is in that of psychology of litigation. Notice that an individual in forensic psychology could assist in many aspects of litigation, even before anything actually began, before the trial has even commenced. Notice that an individual in forensic psychology can assist in jury selection. Notice that this person can assist, say, for example, an attorney in determining which persons are more fit to be jurors. Notice that another role that you may have is noticing and working under the jury deliberation process. Notice that this individual can also assist an attorney, defense attorney, or prosecutor in examining their opening and closing statements. As you know, one of the aspects that an individual may assist in, imagine if a person, say, for example, a defense attorney or a prosecutor, imagine that they're there in trial. An immensely significant part of their job is to be able to present the information, the facts, and what are the jurors expected to observe during the trial. Say, for example, their opening statements. You, as an individual who practices in forensic psychology, you may be able to assist this individual in providing those statements. Also, in the closing statements of a potential trial. So let's revert back to our slides. Notice that perhaps this one is perhaps the most difficult aspects, or at least in my personal opinion, and take that as you will. Cross-examination is the process in which an individual, what they will do, the individual who is in the witness stand, an individual, say for example, the defendant, or an individual who is pressing charges, there may be a time that that individual may have to sit in the hot seat. That individual may have to take up the stand and perhaps make an argument for his or her defense. Maybe an expert witness has to take the stand, character witnesses. So notice that part of that is to be cross-examined, which is the process in which an attorney or defense attorney or prosecutor will examine and will scrutinize what you have provided as testimony with the intent to either assist in the defense or to assist in the prosecution. This is an immensely difficult process. It does take a lot of preparation, but the individual does not have to prepare by his or herself, because a person in forensic psychology can assist this individual in preparing for cross-examination. It is an immensely stressful process because you will be questioned on absolutely everything that you may have said or in the statements that you are providing then, because the intent is to assist either the prosecution or the defense. So a person in forensic psychology can assist that witness in regards to cross-examination. So let's revert back to your slides. Another interesting aspect that a forensic psychologist or persons who assist in the aspects of litigation, notice that it is that of eyewitness testimony. Eyewitness testimony. As many of you know, we would like to believe that our memory works just like this recording here. We like to believe that our memory works exactly like this recording that I am doing, but in reality, it does not. There are many factors that contribute to negative effects of memory. So because of that, one of the things that we can do is addressing limitations and preparing an individual to become an eyewitness, or perhaps assisting in understanding the limitations of eyewitness testimony and their impact as evidence in a trial. So notice that that is another aspect that an individual can engage in. Now, you heard me talk about aspects of memory and their limitations in practice. So I do want to talk very briefly about what memory is and what would a forensic psychologist be interested in regards to research or perhaps practice when it comes to litigation. So notice that we are able to divide our long-term memory. So notice, if I capture your attention, the top right of your screen, notice that we do have long-term memory. Basically, long-term memory is anything that you're wanting to keep for more than 30 seconds. And for example, experiencing a crime or witnessing a crime, notice that that will likely fall within the realm of long-term memory. But how does that work specifically? Although this is a very short overview, I do want to talk about explicit memory. I like to think about explicit memory as the memory you can explicitly recall. Notice that within explicit memory, we also may refer to it as declarative memory. Basically, the memory that I can declare, because it is the memory that I can declare. So for example, what was the defendant wearing? What did you see? The race, the gender, the series of events that preceded the crime, that occurred during the crime and after the crime. Notice that those are aspects that I can actually declare. That is why we refer to this type of memory as explicit or declarative memory. So let's revert back to your slides. Notice that it is the process. This is the process in which I can intentionally try to remember something. So for instance, if I were to ask you, what is the capital of the United States? What is the largest city in the UK? You will be able to intentionally recall this information. Therefore, you're able to declare said information. But notice that we also have another process, right? We also have another aspect, and that is of implicit memory. Notice that implicit memory is not intentional, right? It's not something that perhaps you can recall. This is something that occurs unintentionally, but even though it is unintentional, notice that it does influence our behavior. Notice that we can think about procedures, right? Or procedural memory. So last time you rode a bicycle, you weren't intentionally declaring and remembering the process that you engaged in order to be able to ride the bike. That was simply a process of your memory in which you were able to conduct the steps. So for example, putting your hands on the handle, climbing over that seat, putting your foot on the pedal. Notice that during that time, you weren't actually doing any active recall, right? You weren't actually explicitly declaring that memory that led you to be able to ride a bike, but notice that it was implicit, right? It wasn't something that you were actively recalling. So notice that in this specific case, notice that here you were able to conduct a process, and that's what we like to call procedural memory. Notice that because of that, it is considered a part of implicit memory. Now, notice that memory is not a process in which things occur in a smooth fashion, right? There are many difficulties that we have come to understand about our memory. Notice that one of those limitations can be memory construction. And what is this? Well, we have the ability of starting to add details to a situation that simply were not present in the first place, I should say. This process did not particularly occur. So for example, if I were to ask you, whenever the last time you saw an individual crossing a street, notice that if I were to ask you that information, you won't necessarily recall all of the details, but your brain will automatically start adding details, right? Your brain will start adding details in order to fix gaps of your memory. So for instance, you remember when the person started walking, when they actually crossed the road, but then some of the little gaps in between you were not able to recall. However, your brain will try to make sense of this memory and will start adding a form of construction. It will start plugging in aspects that didn't necessarily occur, right? That didn't necessarily occur in the first place. Now, the thing about that is that generally this intent may not necessarily be malicious, right? Because that is the way that we are wired to be. Our brains do try to process this imagery in a logical sense. So some of those gaps will be filled. Because of that reason, if we revert back to your presentation, notice that we may become very confident. We will become very confident over a memory that is simply false, that simply did not occur. Because of that, in the field of forensic psychology, part of our job is understanding eyewitness testimony. Because along with other many factors, memory construction could make eyewitness testimony faulty. And because of that, because eyewitness testimony can be inherently faulty, notice that it could result in wrongful convictions. As we know, eyewitness testimony is indeed used in our country, in the United States, as a form of evidence. I do need to remind you that in regards of the aspects of eyewitness testimony, in terms of evidence, is considered one of the weakest forms of evidence. And why is that? Well, because of faulty recall. It is admissible in court in our country, but notice that as it goes for types of evidence, notice that it is perhaps one of the weakest forms, and it would be your role as a practitioner to address the strength of this particular eyewitness testimony. I do say that with a little caveat, because you as a forensic psychologist, or you as a forensic practitioner or forensic psychology practitioner, remember that you do not have a legal ability. You do not have a legal ability to make any decisions or any aspect in that nature. That will be the role of a jury. That will be the role of a judge. So many individuals who come into this field like to believe that they have some sort of legal role, but your role is not that of a person who is a judge or a juror. Your work is strictly related to the field of forensic psychology and not that of a person who executes the law. That will be something that is strictly reserved to a judge, and that decision making, of course, to a juror. And I do want to make that very clear, because there are individuals who wrongfully believe that, say, for example, it will be my job to say whether or not a child should stay with his mom or his dad. Notice that that is not something within your scope. What would be in your scope is doing some form of assessment, but notice that ultimately the individual who would be in charge of making said decision would be a judge. So do remember that our practice is limited to the confines of what is ethically and legally required, not, and in that specific case, it's not that involves an aspects of a juror or a judge. And I did want to include that caveat in there for sure. Now, if I capture your attention back to the slides, notice that in regards to our attention, right? In regards to our attention, remember that memory is indeed an active process. Our memory is not a recording. A memory is not a recording, a videotape, if you will, of our world, of our view. It is indeed impacted by many aspects of our environment. Notice that memory is active. Memory is ever changing. So for instance, there are many elements that could come in later on when it comes to your ability of recalling. So for example, perhaps you were presented with new information after you have witnessed a crime, and therefore, is it truly that you are remembering the events, or is it that you are remembering the information that you were presented with after the events? So it is an active process. It is not passive. Now, this is one of the areas that I hold dear to my heart, and that is correctional psychology. That is when we refer to the term corrections, I want you to think about the areas of prison, juvenile correctional facilities, and regular jails. This is perhaps one of the areas that I hold dear to my heart. I had practice under supervision in areas of prison. I used to work at a maximum security prison, particularly in the area of mental health. So working, for example, with individuals who had experienced anger, depression, suicidal ideation, homicidal ideation, persons who were unfortunately a risk to themselves because of the usage of drugs and or withdrawal of said drugs. A lot of the persons that I had a great opportunity to work with and work under also worked in the areas of individuals who were there for offenses related to sexual convictions. So for example, rape, sexual assault, and things of that nature. So it was an immensely great opportunity to me to learn what I know today. And I find it immensely rewarding to be able to work in this particular aspect and hopefully to help, if not just a bit, for these individuals to become better members of society. Notice that what I just mentioned involves that of delivery of services. So for example, if you work in a prison, in a jail or a juvenile correctional facility, notice that you will provide services. So as I mentioned, anger management, group therapy, individual therapy. You will provide crisis services. So for example, individuals who are suicidal or homicidal inside the prison. So for example, an inmate that has attempted to take his or her life inside the prison, a person who almost succeeded in taking his or her life inside a prison. You will work with crisis patients. So for example, persons who have threatened to kill, say, a staff member or a correctional officer. And I do want to remind you, the term is not prison guard. We do refer to these members of law enforcement as correctional officers. That is the correct term. It is not prison guards. It's not considered the correct term. They are law enforcers, just like a police officer. So that is why that is the correct term. So notice that an individual who is in crisis might have tried or attempted or has threatened to take the life of a correctional officer, a staff member, so for example, nurses, psychologists, things of that nature, and they might have also tried to threaten or had tried to take the life of another inmate. So notice that that may be one of the services that you can provide. Notice that another thing that you will be able to do is that of research, particularly research on the quality of life that these individuals may have. So remember that part of their sentencing involved stripping this man or this woman of their freedom. Notice that perhaps you and I may take that for granted, but once that freedom is taken away, there are many changes to the quality of life of these persons. But notice that even though that was part of their sentencing, that does not mean that they need to serve this sentence without dignity. So part of your job is assessing, as a forensic psychologist or a person who works in the legal aspects of psychology within a correctional facility, is understanding the damages of quality of life that this person may incur. So for example, solitude, not being able to see their families, having to, for example, adhere to a schedule, which many of them are not necessarily used to. So notice that there are many big adjustments that an individual will go through once they are being sentenced and are asked, or I should say ordered, to complete sentencing. So part of your job is looking into their quality of life. This is perhaps one of the most difficult aspects to deal with in prison, and that is the aspect of recidivism. What that means is the likelihood of an individual to be a repeat offender, for that individual to return back to prison. Notice, generally, the definition that we have for recidivism is if the person commits a crime in which they will go back to prison within the next 3 years after their release. I have heard other variations of the definition of recidivism. So for example, some states classify that as, say, for example, if the person returns to prison after committing a crime and is found guilty of said crime, if they return after being convicted after 5 years. So I have heard different variations of such. But part of your job as a forensic psychologist or a practitioner of forensic psychology, part of your job is determining, say, for example, the risk that a person may have in order to conduct or engage in crime again. Also, in some instances, you may be working close with parole officers or just with individuals who work under parole in order to grant parole to an inmate who has complied with their parole requirements and is now requesting to be conditionally released and not finish their sentence. So notice that it's a very complex. It is a very difficult role because, as you know, predicting behavior is one of the hardest things to accomplish. Even though psychology is in the field of predicting behavior, notice that it is indeed immensely difficult to accomplish. It does require a lot of training. There's much liability that goes into that practice. Also, a lot of ethical concerns that goes into the practice of assessing for risk and recidivism. But part of that is also after the person is released on parole or after they have completed the time of sentencing. So notice that part of your job could be providing continuation of care. So for example, making sure that the individual has access to resources after they've been released, because now they might have had those resources in prison. Once they are released, they might go back to the same environment that led them to crime, or that had, I should say, an influence in crime. So notice that part of your job is looking into resources that these individuals may have in order to not commit crimes again, or I should say reducing the chances of this individual committing a crime that could perhaps lead them to prison once again. This is perhaps one of the most, I would like to say, centralized aspects of forensic psychology, and that is of profiling. We have seen this a whole lot in areas of popular media, but it is not as fashionable, if you will. It is not as sensationalistic as many individuals would like to think. The area of profiling is another aspect that is immensely difficult, just as that of assessing for risk of crime and recidivism. Profiling is also an immensely complex area. So if we revert back to your slides, notice that in the aspects of profiling, in regards to forensic psychology, what we're trying to do is apply our mental health knowledge. Notice that in this specific case, when you are doing criminal profiling specifically, generally that does require that the individual carries a criminal justice graduate degree. Generally, these persons will create a psychological profile of the defendants, because this can allow some law enforcement agencies to basically be able to minimize the scope that they are looking for. So for example, an individual who does a profile in order to address who may be the person that is considering or has committed this crime, I should say, this individual will look at aspects of mental health and the behavior as represented in the crime scene, as well as other areas of evidence. So for example, an autopsy report. And an individual who conducts a profile will take many aspects, will take many pieces of evidence in order to conduct a profile. For law enforcement agencies to basically start simplifying and narrowing down and targeting, being able to move within a smaller circle of individuals that could perhaps be the individuals who have committed said crimes. Again, this is an immensely difficult field. I know that many of you may be interested in this area, but notice that it is immensely difficult to do. Now, let's talk a little bit more about expert witness. Notice that if you do move into the area of forensic psychology, perhaps the bulk of your work can't be in regards to you being a forensic psychologist that provides expert witness testimony. Notice that, as I mentioned, this will be the bulk of the vast majority of persons who are forensic psychologists. Notice that your role would be of that of being an expert witness. But what is an expert witness specifically? Notice that previously I mentioned eyewitness testimony. So for instance, this makes the person a witness because they have seen a crime. Notice that we also have character witnesses who speak on behalf or against a person or a defendant, or perhaps another individual who we are interested in finding out about their character, about their history. But what is an expert witness? An expert witness is generally considered to someone that is an expert in their field, that is indeed recognized as an individual who has knowledge of a specific area. So for example, an expert witness can be called because of their extensive knowledge and reputation within, say, for example, psychology. And that is what an expert witness is. It's basically a person that is recognized and that does have the background of understanding and assisting in the trial because of their knowledge, because of their expertise. So a defense attorney or a prosecutor may call upon an expert witness so that they are able to provide more insight about the topics at hand. So notice that a forensic psychologist would be considered an expert witness because they have an area of expertise. Notice that part of being an expert witness can be that you are in court because of your knowledge, whether to be to assist in the defense or the prosecution. Notice that another aspect that you could be doing and could be engaged in is determining the accuracy of eyewitness testimony. So if you recall from previously, we were talking very, very briefly about the aspects of memory. So notice that part of your job could indeed be that of understanding how accurate that testimony actually was. Notice that something that perhaps you have heard many times before is that of addressing sanity and the competency of said defendants. Notice that many individuals like to think about insanity as an aspect of mental health. And I need to remind you that sanity is not a concept of mental health. It is not a concept in psychology. Sanity and insanity are aspects within the law. They are not mental health processes as we know them or define it. Notice that this is a topic related to law. Therefore, it is a legal matter. Notice that a forensic psychologist may be called as an expert witness to determine whether or not a person is able, for example, to be competent to stand trial, for instance, being able to assist in their own defense, competency, for example, of both assisting in their own defense to stand trial or their competency to be executed. So that is something that you could be a part of and assist in whether or not a person is competent to stand trial, if there was a matter of being not guilty by reason of insanity, or if the person once found guilty, is this person able to be sentenced? And perhaps that could involve your understanding of whether or not this person has competency to understand that him or her will be executed. So notice that those are matters that you could be helping in when it comes to being an expert witness. Now, you heard me mention this a little bit before. Notice that sometimes you will be called as an expert witness for parental competency. Notice that this involves child custody cases. You may be summoned, you may be hired, or you may be called into being an expert witness to provide an understanding of parental custody. But again, I need to remind you that you do not make that determination. The final determination would be at the hands of a judge. So you will be able to provide assessments. And again, because of your expertise and your knowledge, you may be able to assist individuals who are there. So for instance, a judge in order to make a decision, but you are not the ultimate decisive factor in anything related to forensic psychology. Aspects of custody will be in the hands of a judge. Notice that I would like to give you a little bit of an overview of when it comes to an expert witness. Notice that about only 8% of cases do require that a person has an expert witness, whether it be in the side of the prosecution and the defense. Notice that you, because of your expertise, because of your specialty, you will be able to testify and talk about matters that involve a wide variety of topics. So for example, eyewitness testimony, secondary confessions, and many aspects of the like. Notice that, as I said, you're not the ultimate decisive factor. Notice that it is up to the judge. It is up to decide. It is up to him or her to decide whether or not you are valid as an expert witness. So irrespective of your education or experience, notice that ultimately the decision, I should say, to allow you and to include your testimony as an expert witness does fall in the hands of a judge. Part of that judge's job, part of his or her job, is to determine whether or not your expertise or the manners that you are presenting are indeed actual science. They are actually scientifically sound and validated by your peers in the scientific field. So for example, other forensic psychologists, other researchers, other psychologists, other experimental psychologists. Notice that it is the judge's job to notice and be able to identify whether or not what you are presenting is what we like to refer to as junk science. It's really interesting that this is your topic for today, because I believe yesterday I was watching this individual who is a medical doctor. This person does not hold a doctorate in psychology, but this person was an expert witness for an autopsy, was an expert witness to an autopsy. And this individual was at first talking about her areas of expertise. So she was talking about the results that she had found in the autopsy of the victim that was deceased. And after conducting the autopsy, she was speaking about matters of the autopsy because that is her field. But during the testimony, the defense attorney started asking questions to this medical doctor about mental health. Notice that this is a common technique of individuals who are cross-examining you, because they want you to speak outside. They want you to speak outside of the realms, of the confines of your field, because they know that you are not able to accurately talk about these topics in a scientific manner. So during that time, when the forensic pathologist started talking about aspects of mental health, the judge actually started looking into, okay, well, this is outside of your realm. So the information that you just provided, I don't want that information to be included for the jurors and for the trial, because you are talking outside of the confines of your field. And that determination, I find it to be very correct, because the individual who is a forensic pathologist does not have the background for mental health. It will be the same thing if, for example, I have a background in mental health and I am called for an expert witness testimony, and I start talking about, say, for example, the cardiac arrest that's suspected in the autopsy instead of a homicide. Notice that that will be outside of my realms, and the judge will make the determination that, yes, this is, for example, outside of your bounds, or it is simply junk science. So notice that, yes, that will be something that a judge will do. But that it is really interesting that we had the opportunity to talk about that today, because coincidentally, I was just watching something like that previously. And you may be wondering, this is the bulk. This is the bulk of the work that a forensic psychologist would do, is that of being an expert witness. And I want to remind you, this role is indeed very lucrative. It is a role that is financially viable because you can work as a consultant. You can work as a consultant and work for prosecuting offices, mitigating offices. You can work for defense aspects. So notice that you will be called upon. You can be a consultant because of your scientific experience in the field of psychology. So it is indeed a very lucrative field. It is also a very intense field. So that is something to consider as well. This is perhaps one of the aspects that many individuals look into when we are thinking about forensic psychology, and that is the ability of this person to stand trial. Notice that the definition of competency, it will vary state by state, but most states do fall within do have the same definition. Notice that one of the characteristics to determine if a person is able to stand trial is that the defendant is able to understand the purpose. Is the person able to understand the purpose of this legal proceeding? Some individuals do not have the ability to understand the judicial process. They're simply not able to understand the judicial process. So part of your job is assisting in matters of competency. But how exactly do we know if an individual, what criteria do we use for an individual to see, okay, this person is indeed able to understand legal proceedings? So if we go back to your slides, notice that part of it is that the individual is in fact able to participate meaningfully in their own defense. Are they able to participate meaningfully in their own defense? Because some individuals are simply not able to participate in a meaningful fashion in their defense. Notice that this individual should also be able to understand how is it that they can benefit from consulting with an attorney, right? So if a person cannot understand the benefits or that exploitation that they may have towards an attorney, let me see what this person can do. What benefits do I have in regards to making use of this individual? Notice that if the person cannot assist in that process, perhaps they are not competent. Notice that whenever we do find aspects of competency to stand trial, about 70% of individuals, 70% of individuals are generally found to be competent, right? So out of the 100% of people that try to make a claim for not being competent to stand trial, notice that only 70% will indeed be found competent. Now, the other 30%, there's many things that could occur. So for example, the person is not competent to stand trial. That 30% is not competent to stand trial, but it could only be temporary, right? So for example, if the person receives treatment or further evaluations, we may be able to find a way for this person to actually become competent and be able to stand trial. Now, as I mentioned earlier, insanity is not a mental health term. It is a legal term. Notice that one of the things that we look into is whether or not a person is not guilty by reason of insanity. Notice that this is a legal term, right? This is a legal term. Notice that in this specific case, most of the individuals out of 100% of all persons that try to be found not guilty by reason of insanity, notice that only less less than 1% is able to provide enough evidence and substance to a judge for the judge to determine that they are not guilty by reason of insanity. So generally, a lot of people believe that this must be more common than what we think, and it's actually not. Less than 1% of individuals is indeed found not guilty by reason of insanity. So notice that, yes, it is much less than what we are led to believe, say, for example, by popular media. Notice that individuals who are found not guilty by reason of insanity could indeed spend more time in an institution. If you recall from earlier, I mentioned that about 30% of individuals who are not able to participate meaningfully. So for example, that they don't have competency to stand trial, about 30% of these individuals say are going to found that they are not able to provide that type of assistance in their trial. So perhaps they could be sent to an institution so that we could be able to assist this individual in being competent to assist in their own defense, being able to assist in their trial and be competent. So notice that they will spend less time in an institution, let's say, for example, someone who is found not guilty by reason of insanity. Now, notice that another thing that you can work under is that of civil court, right? So civil court. Notice that we generally refer to this as psychological damages. So within the civil trial, we can find aspects of psychological damages. Notice that we can do so because of those damages. And what could be part of those damages? For example, slander. Slander is a common feature when it comes to psychological damages. Another aspect that I like to mention is that of sexual harassment. Notice that this can also be part of the topics that you could be addressing as a forensic psychologist or as a forensic psychology practitioner in the future. And another aspect that you will be able to work under is that of workers' compensation, right? So for example, a person is interested in gaining or being able to show that they are indeed entitled to compensation because of psychological damages at their place of employment. So perhaps that's something that you can assist in. Notice that we also have aspects of civil competencies. So earlier we were talking about matters that could be, for example, competency in a criminal sense. Let's look a little bit more into the civil side of things. Notice that when we are referring to this specific aspect, there are some individuals that may request or may be unable to make a decision, right? That are unable either because they do not understand the information, they do not have the capacity to understand that information that they are presented with, and therefore cannot make a legal decision. Why is this field relevant? Well, because there is a growing issue for individuals who have Alzheimer's. Notice that part of your job will be to assess whether or not an individual has the capacity to provide and obtain a legal power of attorney. So for example, is this person able to make a decision? Is this person able to make a decision as to another person and them having power over their legal aspects of, for example, aspects of property? So this could be, for example, aspects of a will, right? So for example, a person signs a will knowing that a certain individual or individuals may gain access to their properties upon passing, but did this person have the capacity to understand the power that that will had at the time? So notice that that can also be part of the responsibilities and roles that you may be engaged in. So let's revert back to your slides. Notice that by the same token, not only legal powers of attorneys and wills, but also does the person have the ability, has the capacity to be able to sign a medical power of attorney. And for those of you who are not familiar with this term, basically, just like a will is your wish and desire about what is to happen with your property, a medical power of attorney, what it is what is to happen. What are my wishes and desires? Should I become, say, for instance, have an accident and become incapacitated to make my own decisions? Or, for example, what is to happen if I am placed on life support? So many individuals do want to have this type of legal document accessible to their families so that they know what to do in case something were to happen to them. However, sometimes the person does not have the capacity to make said decision, and that's when a person like you, a forensic psychologist or a forensic psychology practitioner, may come in. So now, this is perhaps I should say something that many of you may not be familiar with, and that is of a psychological autopsy. Psychological autopsy. Notice that when we are referring to a psychological autopsy, what we are doing is generally a clinician would do a post-mortem assessment, right? So the person has passed, the person is not here with us in order for us to provide some sort of assessment. But the intent of providing an assessment after the person has passed is to describe that individual's state of mind. Generally, when a psychological autopsy is conducted, is because we're trying to ascertain whether or not the passing of this person was an accident or a suicide. Also, because of matters of competency, as I mentioned earlier, for instance, the person did not have the ability to change his or her will, but they did, and later they pass. So notice that part of a psychological autopsy would be to determine whether or not did that person have the right state of mind in order to modify their will. Notice that when we are looking more specifically into profiling, what we are looking into is we're trying to determine what are the patterns of behavior, right? We're looking for a behavioral profile of that individual. As I mentioned earlier, notice that part of your job will be to work under civil aspects, and those include child custody. Remember that part of your job will be noting custodial arrangements of a child. Generally, the classic approach was to generally provide that custody to the mothers. However, those aspects are much different now because we have the ability, we have more research to understand that maybe in certain situations that is not perhaps the best venue, the best approach to take. Notice that addressing child custody aspects are immensely challenging, both in the ethical aspect of things, and notice that along that same line, there is a lot of emotional aspects to consider when you are dealing with aspects of child custody, not only for the parents, not only for family members that could also be involved, for the child that is being noted, and also for you as the practitioner. So notice that there are many ethical challenges, there are many emotional challenges that do come from this specific factor. Notice that what exactly are you going to do? What exactly are you going to do when addressing these child arrangements of custody? Notice that what you're trying to do is to assess for parental fitness. You're trying to assess for parental fitness. Notice that another aspect that you will have to consider as a practitioner is whether or not you're looking at a fitness in which the individuals may have joint custody or sole custody of the child. I do need to remind you that irrespective of what your recommendations may be, notice that that is not your decision to make. That is a decision that this individual, a judge, will determine, irrespective of what your determination for parental fitness was. Remember that that is outside of your scope. A judge will make that final determination. All right, and that brings us to the end of this lecture. I hope that you found this immensely informative. It is one of the fields that I am, of course, very interested in because, of course, I decided to have a whole specialty in the field. I find this field immensely rewarding. It's also immensely interesting, and hopefully this video allowed you to get just a little bit more of an understanding of what forensic psychology is.